OCO, and welcome to the inaugural episode of the Cherokee Phoenix Breakdown. I am Tyler Thomas, the executive editor at the Cherokee Phoenix. I am joined today by Cherokee Nation Principal Chief Chuck Hoskin Jr. and former Dean of the University of Arkansas School of Law and former Justice of the Cherokee Nation Supreme Court, Stacy Leeds. In today's virtual roundtable discussion, we will hear Chief Hoskin and Justice Leeds' thoughts in regards to the recent ruling in the McGirt v. Oklahoma case by the U.S. Supreme Court and its impact of the decision in the near and far. Without further ado, let's get going. Chief Hoskin and Justice Leeds, thank you for joining me today.
Thank you, Tyler.
Thank you, Tyler, for having us.
Justice Leeds, I'll start with you. Can you give me a brief synopsis of the case and its impact on Cherokee Nation and the other 5 tribes?
So 2 criminal law cases were involved here, and they were both felonies that were tried in Oklahoma, in the Oklahoma state courts. And after those convictions, the questions were raised as to whether or not Oklahoma had proper jurisdiction in the case, meaning did Oklahoma have legal authority to pursue those prosecutions. And the basis for both of the challenges are this question about whether the Creek Nation's boundaries still exist, the boundaries that were established by treaty immediately after removal. There's a federal statute that governs federal criminal jurisdiction for the U.S. Attorney's prosecutions, and that's where we get the phrase Indian country from. So this federal Indian country definition says that the federal government, and not the states, has jurisdiction inside the reservation boundaries of a tribe. And so there's this ongoing question about whether the reservation boundaries remain intact. And the question before the court is, has there been something that Congress has done in the meantime since the establishment of that reservation up to present that intended to take that reservation boundary away and extinguish it? And so that was what was presented before the court. And in this decision, a 5-4 decision, the Supreme Court agreed with the 10th Circuit Court of Appeals, who had ruled on this case a couple of years ago, and said, yes, the boundaries of the Creek Nation still exist to this day, and there's been no federal statutes, and the existence of the state of Oklahoma itself did not terminate those reservation boundaries. And so with that, it overturned these 2 criminal cases, and now it's proper for the federal government to prosecute these high-level felonies and not the state government. And so that's what we're presented with today in a nutshell.
Okay. Chief Hoskin, can you give me a breakdown of how the Cherokee Nation became involved and its role during this process?
Sure. We filed what's called a friend of the court brief, an amicus brief, when it was going up to the Supreme Court in support of the proposition that the Creek Reservation was never disestablished. And the case, while precisely about the Creek Reservation, really extends to the other of the 5 tribes in Oklahoma. And so we weighed in, I think, as the other tribes did, in support of that idea. Tribes have long believed that the reservations never went anywhere, but we've been, working under these various federal laws and working with state officials, and we know they've had a different viewpoint over time. So now we know the answer, though. So we were there to support the case because it was an important idea.
So the McGirt ruling is about a Creek Nation citizen in Creek Nation land jurisdiction. Does this ruling also extend to the 5 tribes?
Is that a question for me or
for either of you?
Okay. Well, I'd yield to Stacy on that, but go ahead.
Okay, so I'll jump in. And let's be clear, that Murphy case dealt with a Muskogee Creek Nation citizen that committed a crime inside of the Muskogee Creek Nation reservation. The McGirt case actually dealt with someone who is enrolled Seminole who committed a crime inside of the Creek Nation boundaries. So what we're talking about here is Indian country jurisdiction over people who are citizens of federally recognized tribes. So, if a Cherokee person were to go into Muskogee Creek Nation and commit a crime, that would be applicable in this case too. So to your question about the 5 tribes, when the Supreme Court hears this case, they're looking at the specific facts before them. So the ruling itself is quite narrow. It's talking about the Muskogee Creek Nation reservation boundaries. However, the ruling out of it says that unless there's some clear showing that there was an intention to diminish or take away reservation boundaries, they remain intact. And so if you look at the shared histories of the 5 tribes, so many of the federal laws that applied to all of us equally. Now each of the tribes has a slightly different history from a legal standpoint, but it's so similar that we all presume that this case applies to all 5 tribes. And for those that are dialing in from Cherokee country, I actually argue that our treaty language is a little bit stronger than Creek Nation. And so I'm quite confident that this decision applies to Cherokee Nation and also to the other 3 of the 5 tribes as well.
Okay. Chief Hoskin?
Well, and I think it's telling that as we led up to the decision, when many of us were anticipating a win for the idea that the Creek Reservation was never disestablished, that, the state attorney general, I think, was preparing that, as you've seen in the news, half of Oklahoma is now reservation land, because I think everyone understood that the substantial similarity between the treaties, the history, and the statutes that followed, which, as it turns out, did not disestablish the reservations, were similar. So I think we're all on the same footing, theoretically, and that theory will surely come into practice soon. I would think.
My next question is going to be for the both of you. I'll ask Chief Hoskin first. Were you surprised that the ruling stated the court was holding the government or Congress to its word that the Muskogee Creek would have a permanent home and be able to govern themselves?
Well, I think it was the right decision, but I guess if you've been dealing with the United States long enough and have studied history, you're always shocked when a branch of government says that the United States ought to keep its word. So I'm always going to be surprised when that happens. I think I'm always going to be a bit cynical, no matter how good the facts are, no matter how righteous I think the cause is, when any branch of government, whether it's the Supreme Court deciding this case, or, we've gone to the Congress asking them to make good on our treaty provision concerning a delegate, I'm going to be a bit cynical until I see them say yes. So I was surprised, but very pleased, of course.
Justice Leeds?
And I agree with the chief. I was pleasantly surprised, but very nervous about the case. I think all of us that have studied this case for a long time kind of knew that if the Supreme Court really interpreted the law as it existed on the books, we would win this case. But there were so many, rumors out there about how the sky would fall in Oklahoma if this happened. And so the concern was that the justices would fall prey to these perceived practical concerns and not uphold the law and the treaty rights. So I think that most of us in Indian country had hoped for a 5-4 Justice Gorsuch opinion. But until that day actually came, we were quite skeptical.
Chief Hoskin, how will the Cherokee Nation work with local and state governments regarding criminal cases to prevent, as Chief Justice John Roberts said in his dissension, the state's ability to prosecute serious crimes committed in the future?
Well, the first thing we'll do is keep doing what we're doing. We, I think, have led Indian country on cross-deputization agreements. So that means through those agreements, and we've got them with substantially all law enforcement across the Cherokee Nation reservation, that allows arrests to be made, people taken into custody through those agreements. Now, that doesn't get to who prosecutes the person who committed the crime or allegedly committed the crime, but those types of arrangements, I think, are helpful, because I think there's going to be naturally some uncertainty in the public and some confusion. And I think that also goes down to local law enforcement that spend so much of their time every day with a full plate, taking care of law enforcement duties within their jurisdiction. And then they see a case like this, it does have to be maybe unsettling a bit in terms of how they perceive their day-to-day activities. Cross-deputization agreements will help. The other thing is this, a good relationship with the United States Attorney's Office, which we have across Cherokee Nation. That's important because the case, because it deals with the Major Crimes Act, means that the U.S. Attorney has a stronger role in law enforcement in the reservation lands. And so having a good relationship, not only between us and the U.S. Attorney, which we'll continue to cultivate, but also a local DA and the U.S. Attorney. I mean, just yesterday, there was news of the Tulsa District Attorney dropping charges. I think they were homicide charges against a defendant on the basis of McGirt. I think it was in Creek Reservation. I will say candidly, I think it may have caught some folks off guard, including the state attorney general and the U.S. attorney. But I think it could have been handled perhaps differently. Perhaps there could have been better coordination. And then this is from the outside looking in between the U.S. attorney and the DA. I think Cherokee Nation has a role in that. I think we have to keep those players engaged in the process, particularly in these early days. And then finally, we also believe that Congress will react in some way to this case. I mean, the decision pretty well lays out that they could, and I suspect Congress will. And so mindful of that, we're going to use our good relationships with members of our congressional delegation to work with them on any legislative response to McGirt. And if there's one, and I suspect there will be one, Cherokee Nation needs to be involved in that, because I think if we've learned from history, if we're not engaged in the process, we could get run over, and we're not going to get run over.
That leads into my next question for Justice Leeds. Congress trampled on tribal governments during the allotment period. Do you believe that they will intrude on the Supreme Court's ruling?
So I was thinking a lot about this, and when I look at our history, I think that the McGirt decision, as it applies to Cherokee Nation, is in the top 3 most important cases that have ever been decided by the U.S. Supreme Court. The first one being Worcester versus Georgia right before removal. And even though the Supreme Court said that our treaty rights were intact and we had a right to remain there without intrusion, you all know what immediately happened after that. The Indian Removal Act was passed by Congress. And then you fast forward into the 1890s and you've got a case called Talton versus Mays, where we won that case in the US Supreme Court too. And in that case, it said that the Cherokee sovereignty and Cherokee sovereignty only is what can be exercised over our citizens here inside our current boundaries. And that case, if you fast forward to the 1960s, was the case that got cited to severely limit and restrict sentencing capabilities by tribal courts. And so, both of our big wins before the Supreme Court led to some pretty devastating legislation after the fact, citing those Supreme Court cases. So anytime that Congress steps in reaction to one of these treaty rights wins, it makes me very nervous. That being said, I feel like the 5 tribes right now are in as strong of a political position that they've ever been in. And I know that there's, already work behind the scenes in various capacity. So, I trust our leadership of the 5 tribes. But we've got to really be fully engaged, as the chief said, because there's a history of these follow-up responses being very devastating to all of us.
This McGirt case is going to affect many areas. I know we're early on in the after effects of the ruling, but I want to ask about some of these areas and what your opinion is could be the impact in that. Chief Hoskin, how do you see the overturned convictions being handled through the tribe and federal government in working with the state?
Well, that goes back to good coordination. I mean, the sky is falling scenario that some have peddled is one in which people convicted in state courts are let out en masse from prisons, and then it's just sort of the Wild West. We know that's not true. It won't be true if everyone does their job, and part of doing their job is to coordinate. So if there is an overturned conviction, that means that under McGirt, it should not have been prosecuted by the state of Oklahoma. We also know that there are other places to prosecute. So the U.S. attorney has a role. Even the tribes have a role to prosecute, although as Stacy mentioned earlier, there's a limitation on the imprisonment that we can impose. But I think it's about coordination. And so that's how I think we deal with overturned convictions.
How about in regards to law enforcement and the Cherokee Nation Marshal's jurisdiction in regards to local law enforcement and even state law enforcement?
Well, those cross-deputization agreements will remain important, probably more so now than ever, given that under this ruling, every square inch of the map you may be able to see behind me, that's actually a map, Dean Leeds, from 1906. So that's an important map to us. That was before the state of Oklahoma was imposed upon us. But every square inch of that would be something the Marshal Service could have responsibility for. If you kind of take this to its logical conclusion, we would need a stronger law enforcement presence, criminal justice system. But a lot of this will depend, again, on Congress's response and our engagement with Congress and what any legislation that comes out of Congress looks like. But for now, I think we have to start thinking about what it means to take care of our responsibilities for our reservation.
This is pure speculation, but could this lead to more funding from the BIA for the Marshal Service in order to grow the law enforcement agency of the Cherokee Nation?
Well, the next time, Tyler, that the United States meets its entire obligation to fund anything for Indian tribes will be the first time it's done that. That said, you can rest assured we will press the government of the United States to meet its funding requirement as part of its trust responsibility. And so we'll take a run at it. But I think what we've learned is if we wait around for the government of the United States to fund everything, we'll be waiting forever. But it won't stop us from pressing them on it.
Justice Leeds, what, as a former justice of the Cherokee Nation Supreme Court, what would be needed to get Cherokee Nation's judicial branch ready to handle some of these cases?
Well, if it was, like the principal chief said, the logical conclusion in that there was full-blown jurisdiction, we would need to go back to the days that we were in the 1890s, where we had district courts scattered throughout our jurisdiction. If you had something that came up in the northern part of the Cherokee Nation, you wouldn't want those parties to all have to come to Tahlequah. So it would be a broad expansion of our judicial system. And then I think most importantly, the law enforcement piece. We have excellent judges right now that can handle a lot more cases than they even have on their plate right now. But yeah, I mean, a full ramp up would be your court system, your prosecution, your law enforcement, investigators, whatnot.
Justice Leeds, how do you see taxes being handled now under this ruling locally at the county level and state level?
I think one of the biggest misconceptions about McGirt had to do with the ownership of land itself and what that means for local and county tax bases. I think all of that is quite clear. It affects ownership and title of land in no way. We're talking about reservation boundaries for jurisdictional purposes. So, all of these pieces of land that are already on the county tax rolls, those aren't coming off. There's already federal legislation that said after the allotment, after restriction is lifted from those lands become fully taxable. So I think that that's one piece that no one in the state needs to worry about. I think it's going to have a bigger impact on the civil jurisdiction type questions like Indian child welfare, and maybe other types of taxation, not taxing the land itself. But the Supreme Court has been very clear in a number of cases that says the state has no inherent taxing authority inside of Indian country if that tax is being levied on Indians. So, the question about income tax, right? If people are receiving all of their income inside of their own tribe's jurisdiction, there's probably a very strong claim that the state has no taxing authority over that piece of activity. So I think those are the things that are immediately on folks' minds. And you haven't quite asked the question yet, but you're trending toward the Indian child welfare, and I mentioned that. In the Indian child welfare federal legislation, it defines jurisdiction very clearly. And it says that where an Indian child that's subject to the act is domiciled on the reservation, then the tribe has exclusive jurisdiction. So it's not even shared jurisdiction between the state and the tribe. So that can have a really big impact on the docket size of our Indian child welfare and, questionable transfer of jurisdictions pretty immediately from the state court to the tribes on that same jurisdictional question.
Chief Hoskin, do you share that same sentiment in that this decision helps strengthen the tribe's stance on ICW?
Yeah, it does. Now, the Indian Child Welfare Act itself contemplates that states and tribes might enter into agreements concerning jurisdiction. And so those conversations are going on right now, given what Dean Leeds just mentioned, that there's exclusive jurisdiction is the presumption under the act. So I think we're going to have to work through those kind of questions, because we want to make sure children are protected. It takes resources to do that, the Supreme Court's good at issuing decisions, but they have no role in making sure that those decisions are accompanied with the funds needed to execute. So we've got to be careful about that. Children are precious. We don't want to give up any of our rights under ICWA or any of the rights of the kids or families in question, but I think we're going to have to work with the state to make sure it's workable.
Working with the state leads me to a couple of my next questions. Cherokee Nation, and I know a few of the other 5 tribes have hunting and fishing compacts with the state. Does this McGirt case have any impact on those compacts and the hunting and fishing rights of the Cherokee people and other citizens of the other 5 tribes?
I think our rights are the same, and the dean has studied this more than I have, but I think our rights are the same, and that we have a strong argument for hunting and fishing throughout our treaty territory. The decision certainly didn't hurt when it said that our reservation wasn't disestablished. Right now we have a compact, which we are, of course, it's our discretion to do, and we've done so. So the compact remains in place. I think our rights remain the same, perhaps strengthened.
Dean Leeds?
I think it strengthens all of our compacts. The premise in all of those compacts were already that we had political and territorial boundaries that mattered. And now we have reaffirmation of that. So I don't think those compacts go away at all. I think they're stronger. And, the big question is, when it comes time for those to be renegotiated, are we standing in the same place as we were when those started? And, most of those compacts have been very good for all parties involved, but I certainly don't see any diminishment of our rights in any way.
Okay. Chief Hoskin, given the environment of the dispute on the gaming compact between the governor's office and the tribes in Oklahoma, what kind of impact will this case have on that dispute and that agreement and so forth for gaming in Oklahoma?
Well, the Congress can make laws to affect the relationship between states and tribes, and they've done so in the area of gaming. And they've said that when it comes to Class 3 gaming, that essentially the Las Vegas style gaming, that there has to be a compact, has to be an agreement of some kind. So that hasn't changed, but all of these conversations that we'll have with the governor going forward take place against a backdrop of a Supreme Court that said the government ought to keep its word, that our treaty territory, our reservation is intact. I always like to go into a discussion with the governor with that standing behind me. But I think we're in the same posture in terms of a compact for the future of gaming is what we want.
Justice Leeds? I don't think it impacts gaming except for the political context. The jurisdiction that the tribes exercise in order to game has long since been recognized. So I look at this McGirt case first in the context of criminal jurisdiction, and then the general civil jurisdiction fallout from that. But I put gaming on a different shelf altogether.
Chief Hoskin, the 5 tribes are expected to present Congress in the DOJ a plan addressing the jurisdictional issues. When do you think that could be ready, and what all will it entail?
Yeah, so it will ideally be something jointly with the Attorney General of the state of Oklahoma and the 5 tribes. I think it's a matter of weeks, not months, before an initial outline is presented. Primarily, it really would deal with the criminal jurisdiction aspect, which is what the immediate concern of the Congress will be. I want everybody to realize it's not that the tribes see this decision and we immediately have some anxiety about it and are running to the Congress for help. What we are, I think, is, and I know this because I talked to the other of the 5 leaders really weekly and at a minimum lately, is that we are mindful that, as history has demonstrated, and the dean mentioned it earlier, Congress will respond. That's a given. There's no question about it. It's not even a theory. I know they'll respond because I've had conversations with members of Congress. The question is whether the tribes are going to assert their strength in the process, and we have to. And so I want people to understand the context in which we would make an announcement with the state attorney general and members of Congress is because we want to be a part of it, not be run over by it.
Chief Hoskin, Justice Leeds, is there anything more you'd like to offer before we end this roundtable discussion? I'll start with you, Justice Leeds.
Okay, the only thing that I just want to conclude with is there's just a lot of misinformation out there. And I think that if there's one thing that all of the tribes and the state and the U.S. Attorney's Office have in mind is that they want, number one, public safety to be dealt with. And so, we're all immediately working together. You have already seen news in the last 24 hours about a couple of cases that are impacted by this, and the U.S. attorneys are already involved in some of these serious crimes. But what this case does is that it takes jurisdiction that had been presumed to be exercised by the state. It takes that away, and in the vacuum, it adds 2 other sovereigns that can also and will prosecute. And so I just hope that people don't continue with this lawlessness narrative, because it's just not healthy and it's not accurate.
Chief Hoskin.
Yeah, well, I agree with what Stacy just said. That's 100% true. More broadly, I want Cherokee citizens to be very proud of what happened and be very hopeful about the future, because what happened is the promises that were made to our ancestors. You draw a direct line from the Cherokee leaders of today, of Cherokee Nation, the citizens of the Cherokee Nation, back to those folks who stood their ground, back to those folks who gave up so much but did not give up. And by not giving up, they remained a people, and they remained a people that could exercise sovereignty through their government to deal with the government of the United States, to sign treaties. Those treaties are still alive and well, and the jurisdictional boundaries set out in those treaties, again, by our ancestors long ago, are still here. And it's not just us saying it, it's the Supreme Court of the United States saying it, and saying it really in one of the most powerful ways that I've seen. So it is a great day for Cherokee Nation. And I think in some ways really a vindication, again, of all the great work and sacrifice of our ancestors. Now it's incumbent upon us to do something on par with that, and to be the kind of people that we want to be and the kind of government we want to be to serve our people. This just really, I think, emboldens all of us to do more.
Well, thank you, Chief Hoskin and Justice Leeds, for helping shed some light on the significance and impact of this ruling. I also want to thank our audience for tuning in to watch the inaugural Cherokee Phoenix Breakdown. What up?
Hello, Tyler.
Thank you.
Thanks, Stacy.
Yep.